Good afternoon, ladies and gentlemen. My name is Oleg Fursov. I'm the head of multi-family office of financial group BKS, and today we are holding a roundtable on the theme Amnesty of Capital. It is necessary to make some introductory remarks, and I will start my introductory remark. Allow me to welcome the participants of the roundtable dealing with an extensively discussed theme of capital amnesty in the context of social economic situation in Russia and geopolitical trends. That theme is particularly urgent. Undoubtedly, it is worthy of being discussed at the 5th St. Petersburg International Legal Forum. As I have said, I'm the head of the Department of Multi-Family Office of the financial group BKS, which this year celebrates its 20th anniversary. Our bank, BKS Ultima, that has agencies in St. Petersburg, Novosibirsk, Moscow, and Ekaterinburg, provides services for the wealthy clients and provides individual private banking services on a broad range of financial tools and instruments with support of analytical experts of BKS Financial Group. We consult our clients on the broad range of themes, including amendments to the law. For many wealthy citizens in Russia, the question of desurization and capital amnesty is quite important. Thus, we organized this roundtable, and I hope that today's discussion will be not only interesting but useful in all the respects. In order to pass on to that bridge from the official part to the presentations of our speakers, I would like to touch on the history of financial amnesties and capital amnesties which occurred in the latest history period of Russia. Just a few words about it. If I'm not mistaken, such attempts of financial amnesties in Russia from the early 90s were 5 in number. The first was in 93, which was organized in such a way that within 1 month the people who haven't paid taxes had to do it by the order of the state, but that amnesty failed for the following reason. The main cause was that the state wanted to get everything, giving nothing in exchange. In 1995, the Ministry of Science of the Russia proposed a new option of financial amnesty, following which the funds which were invested into the innovative technologies would not be subject to declaration for several years. Unfortunately, this initiative has not yet been realized. In the autumn of 1997, President Yeltsin proposed to organize the next financial amnesty with payment of a special duty of 10% of the legalized amount. But unfortunately, since at the level of ministries that couldn't coordinate this draft law, they were not even submitted to the State Duma. The question of financial amnesty was also discussed in 2000. In 2002, 2 draft laws were developed that were not implemented, unfortunately. On the 1st of March 2007, the law was enacted in Russia on simplified procedure of declaration of revenues by physical entities. And according to the legislators, till the end of 2007, it was necessary to realize the provisions of this law in relation to the amnesty of capitals. The result showed that, for instance, as of December 31, the arrivals to the treasury were only 3.7 billion rubles, and the taxes recovered in 2007 were 7.8 trillion rubles. There were several reasons why this amnesty was not implemented. There was an atmosphere of mistrust between the state and business. There were no adequate guarantees of the state, and the question was not solved as to the people who didn't want to legalize their assets. Another important issue, there was not enough awareness of the community about the amnesty. Polls showed that only 6% of the respondents said that they were aware of that amnesty. Departing from the rhetorical question in Russia, who is to blame and what should be done, today, with the assistance of my colleague speakers participating in that roundtable who are absorbed deeply into that issue, probably we would ask correct questions related to the forthcoming approval of that enactment of that regulatory act, and we'll discuss some applied issues as to how that will be implemented in life. Because I work with well-to-do clients and I receive a lot of questions concerning this matter, and that is quite enigmatic for everyone. Probably that is not related to that theme, but I will take that opportunity because I'm not always sitting at the same table with the deputy of the State Duma, Andrei Mikhailovich. I would like to address the deputies of the State Duma so that I haven't said anything that would be offended, and you're just speaking about the deputies. I'm not offensive. My question is, I would like to ask our legislators, when solving such questions, they should apply an integrated approach, because unfortunately, the diversity of legislative acts that are adopted and a major problem with the legislation on currency regulation, for instance, the draft law that is at the State Duma, and has been approved in the first read in the February 2015, but it is not moving. That concerns the regime of accounts opened by physical persons at foreign banks, Article 12. And the adoption of such amendments would probably promote the fact that the assets that is discussed by our state will be withdrawn for the shadow will be operating for the economy of Russia. I wanted to open an account with your bank, but I don't have enough funds. Secondly, since you are addressing me as a deputy, and we are present here as lawyers at that forum, but I address you as a deputy to the lawyers. We adopt your request, though that law is considered by a different committee. But my request from the deputies to the lawyers states that you should not only talk about the laws, but first you should read the laws. Now I would like to give the floor to my colleague Mikhail Sergeyevich Kazantsev, co-moderator, who in his turn, I think, will launch our today's discussion. Thank you. Thank you very much. I would like to say a few words about the history of forming the ideas that served the basis for development of the draft law that has been subject to the first reading now. It happened so, and historically, consulting the Ministry of Finance, I became a member of the working group on development of the concept and draft laws and preparation of the first version, which was amended to a significant extent by subsequent operations. Initially, when the working group for development of the draft law was formed due to the statement by Mr. Putin, who outlined a global and catch-off amnesty, so will pardon everything to you and will never recall anything from the past. Then it appeared all of a sudden that what is against such a role, and we had to correct it, understanding that Vladimir Vladimirovich cannot be mistaken, and we just don't understand what he wanted. We tried with participation of the Minister of Finance, Ministry of Justice, Ross Financial Monitoring, Tax Services, and other departments to determine how to form the amnesty, which on the one hand will grant pardon and remove the historical risks on the one hand, and will comply at the same time with the international obligations of the Russian Federation on legalization and laundering of money received from terrorism and drug financing. There were a lot of conceptual approaches to pardon everything to everyone. It was not possible. Who will be the subjects of amnesty? Initially, it was proposed that these will be physical and legal entities. Then it was said that it is too much, and legal entities should not get the right to amnesty their operations and property. It was long discussed whether taxes should be paid or not. Surprisingly, probably this is one of the few, or probably the only amnesty in the practice, in the global practice, that doesn't involve payment of any taxes. And major questions were also related to the fact whether it is necessary to disclose the sources, the origin of the property. It is not written in this wording. The declarant can indicate it voluntarily. Those that some questions that anything can be declared without disclosing the sources, and that draft law didn't envisage any checks on the declaration submitted. So what will happen with monetary funds and assets received not under the articles that are being amnested? Coming back to the lawmaking process, Ministry of Finance have drawn up the first version of the draft law that was significantly finalized and updated by the State Duma. And I believe that the first wording of the draft law was mostly declarational. It granted the right to declare property, but didn't envisage any real measures to protect or real guarantees which the declarant could use. The second and the third versions, in the second and third reading of the draft law, expanded the rights of the declarant and restricted the rights of the public authorities to make checks on misuse of the information that has been declared. But, however, in my view, there were some technical problems that haven't yet been settled, which on the one hand I believe were not of conceptual nature. Probably there were some technical faults, but they might decrease significantly the number of persons who would be interested in the amnesty. That is related to the hazards of the business and potential distrust to the state to disclose anything at all. And finalizing my presentation, I would like to give the floor to the only person who really understands the essence of the law. Andrei Mikhailovich will tell us who was the target audience of the law and who is planning to use it, and whether there will be guarantees assigned to the law by our law enforcement bodies. Will they be implemented, and should the people declare? Thank you, dear colleagues. It is the first time that I attend a legal forum, and I have heard a lot about St. Petersburg Legal Forum, and there were a lot of good words pronounced, and now I'm just in a rather strange condition. I have a feeling that I'm not among the lawyers, but among the historians, and we're mostly interested in the matter concerning the history of creation of drawing up this act. Since we have to combat with such imperfect interpretations in history. I would like to dot all the I's, though they told me what I am going to talk about, and if I deviate, probably I will be stopped, and being deputy, I can press the button. I will just press the button and the microphone will go off. So the history of the matter started much earlier than the Ministry of Finance. Before the Ministry of Finance started attracting some law firms. I don't quite understand how the law firms are attracted on certain cases. Sometimes they are determined as the sole supply of the services. I understand it when some unique equipment is supplied. As to the legal services, how can you determine the company or the law firm which can be the only company to grant that service? That is really a great enigma.
So this story began somewhat earlier, in August last year, when at the meeting of Vladimir Putin with the deputies of the State Duma in Crimea, in Yalta, one of the deputies, and that was me, asked a question. Now, Mr. President, and what do you think of the economic situation our country is in? It is obvious that we are not going to see sanctions abolished, pressure lifted, and the measures taken by the state lead to the frightening of business. And what do you think of the amnesty of capital? Putin said at the time, no, he said, our experience had been different, and I did not want to forgive everybody for everything. But if you draw a law, I'll sign it. That's how we began to work on the law. Then there were certain requests from the government. The text of the law was prepared. I'm not going to analyze the text since I'm not a historian, but when the concept of the law began to be discussed with the Ministry of Finance and with the government, it became clear that the president had meant something different. And then, by the decision of the first Prime Minister of the government, Shuvalov, a work group was established. And Shuvalov suggested that I lead the group, and could not understand why, if I could not carry out the work in 4 months, I would be able to carry it out in 4 days, but I could not say no nonetheless. So we actually draw the new text of the law. Now, the old text is still there. The original text is still there. Of course, you can refer to it. And the law adopted is a different law. These laws are about different things. These are important matters, so let me have a drink. They are about different issues, but what is most important? The President formulated his requests in 3 of his statements. That was the statement to the Federal Assembly, the press conference when he answered these questions to the journalists, and his presentation in the Russian chamber. And these give a clear idea of what the president understands and how he sees the future and what needs to be done. It all seems to be simple. I led the group, and I mentioned that. I just want to relieve from responsibility all the others who worked on the law. It's a unique law. If it is, we didn't have any experience of other countries to rely on. So if this law works, then that will mean that many people had been involved. If it fails, then the responsibility is entirely mine. So the president said, we must turn over the offshore page of our economy, the offshore page of the history of our country. So let's give an opportunity to the citizens, not business, but to the citizens, to declare what they have, to declare what has not been declared. Let them have a chance to declare this without any consequences, with the guarantee that no one is going to ask any questions. This was perceived as absolute forgiveness by some. So let's turn the page. That's what the president said. And then he also says, well, of course, this should be coordinated very carefully with the agencies, and there are no concessions. I spoke to the FATF experts, and then the financial monitoring was introduced. And so when, with great pleasure, I listened to Shatalov's words, who worked on the first option, that FATF requires the amendment of the law. That was quite interesting for me, because they actually supported the version presented by us. That's all quite interesting, but that also indicates that many of the lawyers, as well as reporters, do not understand yet that the parliament in Russia does exist, and that tax laws and the budget laws are adopted by the parliament and not within the offices of some ministries. And the public discussion is inevitable, and the laws are drafted, presented to the parliament, and are to be discussed. Then the next issue to draw your attention to. When we received the request of the president, what we're to begin with, I disagree with you on a principal matter with just one thing. When you say that the tax amnesty of the year 2006 failed, but that amnesty was prepared by me, and I know exactly what the task was and why it was being prepared. 13% was mentioned, not in order to get some resources, but in order to prove to those who make use of this amnesty that they can feel free, that none of them were going to be prosecuted, that they would not be interrogated, they won't be even questioned in connection with the tax payments, and just to make sure that none of them would feel uncomfortable. So, I mean, the main achievement of the amnesty of the year 2006 was exactly that. For the first time in the tax sphere, the government, the state, was true to its word to 100%. So, relying on this experience, we were to draw, following again the decision of the president, a simple, understandable, and economically efficient mechanism that would enable people to declare what they have. So this mechanism included legal protective mechanisms, the criminal code, the procedural code were part of that. The materials cannot be used as evidence, as a basis for different inspections. They do not make it possible to question tax inspectors, and so on and so forth. You must have read the text, and you can see that all the guarantees are stipulated in the law. When they say that the Minister of Finance introduced this law to the Duma and then were continued in the lower Duma, no, colleagues, then why would it be so that in that law we would not give the list of articles, but just mentioned the special resolution of amnesty? Because there are the best practices that always say that the government must coordinate all the articles. Had we mentioned all these articles in the law right away, then we immediately would have been rebuked for the lack of coordination. Everybody knew that. This was discussed at the meetings with Prime Minister. It was mentioned quite clearly that during the second reading, all the norms of the criminal code must be directly formulated. It is not surprising that we said that by the federal law will define the format of declaration and the order of its filling in. So there is no other law, and there cannot be any other law. So the format, the order of its filling, established by the law. But we would like this form and this the order of its filling to be displayed on the site of the Federal Tax Authority. They did that, and discussion continued for almost 6 weeks in order to understand what was to be changed in the declaration, so that this would never make those people who want to use this amnesty uncomfortable. So declaration consists of 2 pages, just 2 pages. It's the identification of the individual, and then everything else is the wish of a particular person. If the person wants to declare something, he or she declares it. But how can we relate all of that? Now, there were different proposals. Let's relieve deals. The president never spoke about the relief of deals, and that was very proper, because if we say excuse for everything, then the one who robbed the central bank. Now, should he enter this information into the declaration and be amnestied for it? So we are following a very strange pathway. It's very difficult to find the boundary, and that is why we coordinated everything with FAT, realizing, of course, that we discussed the tax offenses, foreign currency, and some other offenses as well. And then, second, the person declaring should always realize that that nobody is going to persecute him in the name of the company, because a company, for example, doesn't fill in a declaration. The director doesn't do it. The accountant doesn't do it. Well, there were many options, many ways out. Declaration could be filled in by the third parties. I particularly like the wording. Declaration by the third parties about the instances that they are aware of, or they can grounds to assume that somebody has committed a tax offense, so even a tax crime. What a good text. Just imagine, if the text is adopted, then we would have had so much more to discuss. That was exact quote. And then we approach a very fine edge. How to create guarantees for an individual without facing a situation when somebody declaring an apartment for $15 in Bulgaria would report that way for the billions of taxes unpaid here. So we related taxes to the source of the declared assets and property. So immediately we excluded cash. But cash was also suggested to be amnestied. Just imagine, amnesty of cash. No, FATF would have never agreed to that, but it seems to me that the lawyers are reasonable people, and even well, trying to earn as much as possible, they would never do that. Cash is a different matter. So what is there in the law allows us to release really the whole chain, but only if only in connection with what the person declares. But where is the connection between the individual and the company? Obviously, this refers only to those companies to which that individual was somehow related. Well, of course, if the resources were provided through some money laundering entity that had thousands of these deals, it would have been impossible to release that particular and to relieve that particular agency. So this connection is established by law. And then another important moment, what are the guarantees? Guarantees of a person feeling free and not prosecuted. You all know that the Federal Tax Authority acts as a depository in this case. By the mechanism that it's exactly that, the declarations submitted and the tax authority that accepts it, and really the decision here to accept this declaration should be quite high, because actually you can deny the acceptance of the declaration. But you have a copy, so it's the only case when the copy does not comply with what you have submitted, because on your copy, you have a stamp of the tax authority. And with that, the authority of the tax agency is over. You seal it in an envelope and keep it in the federal authority. That's it. Nobody can read that text. The tax authorities, the investigatory authorities, they do not know that the declaration is there. And you are the only person who can actually make use of it. The person who declares, we believe, is a person of common sense and a reasonable person. And only the person who fills in the declaration can use this declaration in order to explain that he complies with all the law provisions. In case he is charged with something, there are no other instances when this declaration can be used. And one final thing, because I take up too much of your time, but being a lawyer, yes, I tend to talk. I have been in Duma since 1993, but well, old habits die hard. So the final thing I wanted to say is that there's actually a difference between me and the majority of those who are present here. Anyway, so very often they ask, and will people make use of that? Well, I can of course refer to dozens of different people calling, saying thank you for the law. From SMEs to large businesses, but these are just words. They're not recorded and cannot be an evidence, and I do not know whether they're going to make use of this or not. For a very simple reason. The trust to the state and the tax system is not defined by the law adopted recently, is not defined by the group of laws adopted or to be adopted. That's a very different factor. And so what is the basic difference between the year 2006 and now? In those days, most of the people believed that the resources abroad and assets abroad are protected better than in Russia. We know that beginning with the 1st of January 2017, we can read the new directive on money laundering. Everyone is to adopt the law, and all the beneficiary owners will have to be in the official list. Beginning with 2018, the tax authorities officially, and in 2017, in the form of testing, will get not just information about Ivanov, Petrov, and Sidorov, but will get all the massive of this information. And as a person following the instructions of the president, I'm talking about the position of the president in relation to that. He said, I do not want to see a situation when in January 2017 hundreds of people turn into criminals. So we give them this opportunity once, just once, and we don't trust the laws that much. We trust much more the signals. The president said, I personally am going to work on that. He publicly said that. He spoke about his personal involvement. He said that he didn't want any of the power structures to make use of that to their benefit.
That's why the law reflects not that the resolution on the criminal case will be based on the resolution of the investigator office and the general prosecutor, but we raised the control to a different level. If the investigatory department concludes that the information contained in the declaration does not fully cover the range of claims, not related to that particular declaration, and if they are going to refuse the termination of the case, on the one hand, we raise the level of the decision-making to the level of the head of the investigatory body, and that decision is immediately submitted to the general prosecutor by and to the authorized person on business matters under the president, because president said that he is going to engage in this in person. That mechanism is described by the law, and it will be operational. I would like to think that everything that is described by the law being a practical law, and many people know that during the Soviet time, probably I was one of the few lawyers who had 5 sentences stating that the persons were not guilty. And I think that the law covers all the possibilities of misusing. And we have provided to the people an absolutely safe possibility according to the order of the president of the country. Whether they will use it or not, I don't know, but that is their last possibility. Thank you. Andrei Mikhailovich, if you allow, a couple of questions. Why, in the last wording, there was a necessity to notify the authorized person on the rights related to the business? If you said that the amnesty was not for business but for citizens, I'm going to explain. It is quite obvious that a significant part of the questions that will arise are related with business, and we draw a link from the property of a particular individual, which is declared to the companies through which the means are liberated. If there are some problems with the director or accountant or the holder of the company, the owner of the company, we think that in this case the president should be informed by the person who is protecting business. Probably we could find other mechanisms. We might write to the presidential administration just elsewhere. We have found the shortest route when the information will be received by the president on the question of interest to you. That is also for business, I think. I don't quite understand. Do you really think that this law applies to it? I don't remember that there would be certain exemptions from the law. We will make exemptions concerning the crimes to which it doesn't apply. And there are some, exceptions from the viewpoint of people that are already known to the state, because declaration of the property concerns the facts that are not known to the state. And from the 15th of June, everyone should notify about participation in kicks. And when the president made an order to synchronize, and when we postponed them for 1.5 months, there was an order to synchronize it, and we performed it. And everyone should know that the persons who notify about participating in that body will have no responsibility. On the one hand, we create transparent economy. We have notified, and we say that there is no responsibility in the past, and then the tax base will be formed. Where taxes arise, they will be paid, and amendments take into account the amendments that was asked by the business. Irrevocable trusts, assets of the company. We shouldn't separate the text from one law from the context of transformations that will make our economy transparent, but that a law not granting pardon to all the people, but those who want to really become transparent today and to declare what they have, not to think whether tomorrow they will be visited by racketeers or all enforcement bodies. They can do it. We're providing the safe mechanism. As to for whom this law is more important, for the teacher of the English language who trains students and who has bought an apartment in Bulgaria, or for the business who has removed the money offshore to reduce the tax load. I'm not ready to discuss it. For instance, $15,000 for that apartment in Bulgaria is much more than several $1 million for business. I wouldn't divide the citizens into businessmen and other citizens. That is done for the citizens of the country. Thank you, dear Mikhail. A very interesting innovation in the second version that pardons granted not only to law violations related to the property, but to the sources where from the property is formed. You have said that the possibility of declaring transactions were discussed and it was abandoned. And what was to replace it? What are the sources of information? The first ruble or dollar earned, which a person earned washing cars at the age of 15. I remember, Michael, your idea that we have to trace the chain from the first ruble, from the heritage left by the grandmother and exempt everything. I'm not a good lawyer. I have never worked in such a wonderful company as yours. We didn't have so many advocates to do it. We proceed from the following. Property is declared, and what is related with that property is exempted. The person himself decides whether he should indicate the source of the scheme. He knows that most of the tax amnesties in developed countries proceeded in such a way that the scheme should be provided. We said no, and the question was really discussed. There were proposals just to declare everything. I think if we said declare everything from the viewpoint of safety of the person, that would be more correct, but no one would believe it, because when we're saying everything, people might have questions. We're saying just declare what you think should be declared. Then the person will declare the thing where he has doubts, where he thinks that people might come and claims might be raised against him. And the mechanism provided for by the law in that case allows, when the person declares, to relieve him of the responsibility, and those individual physical and legal entities that participated in acquisition of the property. I remember that discussion. It can be said that I have just bought shares for $1 billion and my company was bankrupt, and I would like to declare that billion. You won't be able to do it. I don't really know how to do it. We abandoned that idea jointly. You also have abandoned a safeguard. So we think alike, and that's really great. What do you mean by the source? Because if you declare a company, for instance, you shouldn't declare the sources of forming the assets, because according to that law, there will be an automatic, not at all. Let us give some specific examples. I have been working for 22 years at Duma. Probably I have become a little dull. As the simplest example, for instance, you hold a company in Russia. You are the owner of that company. You have the director, CEO, you have an accountant. That company evading taxes moved some money to your company in Cyprus. That is a real situation. Naturally, that money was removed to Cyprus, transmitted to Cyprus. Having read that law, you realize that finally you want to declare and to turn the offshore pages and to start life anew. You declare the fine, $1 or $10 billion, I don't know your revenues. So you declare the funds which are at your company, that is undistributed profit, and you have to pay taxes from it. And you say that these funds have not been transferred by this or that company, Pushkin and Sons, for instance. As a result, they won't come to the company to levy their profit tax. They won't have to restore their accounting ledgers, and the CEO and the accountant will automatically be not responsible who have transferred 1 or 10 billion. We can develop that situation and analyze any of the options. If the CEO of your company or an accountant have deceived you and they have transferred additionally 10 or 20 billion, probably we shouldn't exempt them from that responsibility, so we can relieve only the amount that was declared by you. And the exemption for the third parties should be related by the funds declared by the person who uses that right. If it is done by the CEO or accountant, they also have the possibility to declare their funds. Andrei Mikhailovich. So if one of the persons has declared and is assigned to the company, this is just a reason for checking the company. There is no reason for checking the company, and only you know about your declaration, not a single person. And this company, because you have submitted, the declaration will come to the company. It will be impossible to come there. But we are not stopping the work of law enforcement or tech authorities. They might come to that company to discuss other questions. And if you are related with the company, you can say that you have submitted the declaration. And if it is just a money laundering body, you're not going to do it. That is based on good reason. But that guarantees that not a single person related with declaration will be made criminally liable. And the persons who are not related to these amounts or have exceeded the amount will not be relieved of the responsibility. That is the question of justice. Criminal responsibility on the basis of the declaration, you cannot make a person responsible, criminally responsible on the basis of the declaration. No one has got the declaration. Only you know that the declaration was available. The law states that on the basis of the declaration, not a single procedural decision can be passed, and you only you can use it as a proof. If you just submit it as a proof, they have to agree with it. If I don't understand something, please tell me and I will recognize it. We're having a very lively discussion. Valery Gradnitsky will ask a question. And Andrei Mikhailovich, well, a person of the same name. I know that you have read the law. What questions have you got? We have been acquainted many times. Could you call me and ask beforehand? Probably it will be interesting. Article 6, repatriation of property. We are not interested, I'm not interested in the conditions, whether it is included or not included on the blacklist. The state that doesn't provide information exchange for the purposes of taxation with the Russian Federation. We're saying that we have ratified the convention on mutual administrative assistance in tax matters, but we know that initially the territories where the Russian interests have existed, such as Liechtenstein, Switzerland, Cyprus. Do we have interests? Yes, we have significant interests there. That's horrible. To a lesser extent, Luxembourg or the UK, not all of them have ratified this convention. They are delaying ratification. Switzerland and Liechtenstein, I think Washington interferes. They start exchanging information from 2018. By the 1st of January 2016, it might appear that these territories, the territories of our interests, will not be able to ensure exchanging information with the Russian Federation for taxation purposes. Does it mean automatic repatriation of the property? Well, you have understood what he meant, but Andrei Mikhailovich knows me well, and I have to explain it in greater detail. Will you read the current wording of the tax code stating that this list is determined by the Federal Tax Service Department and it will be issued simultaneously when the law is enacted? Thank you. I suggest that we continue our discussion. Can I take my seat? Thank you very much. Thank you very much for that interesting information. Andrei Mikhailovich, thank you very much for your presentation once again. You called me a historian, but I'm not offended. In fact, I have to play such a role today. But nevertheless, we needed to discuss the history because we had to proceed from the amnesties that were implemented, whether they were successful or non-successful. We had to realize the causes why a certain amnesty has not been implemented. One of the reasons, for instance, the amnesty of 2007, that was an atmosphere of mistrust between the state and business. We have some speakers who are going to elaborate on that theme. Now I would like to give the floor to Alexander Vasilievich Brosov, plenipotentiary agent on protection of the rights of entrepreneur in St. Petersburg. He will speak about the level of trust between business and the state, whether the rights of the entrepreneurs are defended under the frames of capital amnesty. Good afternoon, dear members, dear panelists, dear speakers. I would like to mention the following after Andrei Mikhailov's presentation, who popularized the law on declaration of the investments of the contribution deposits. That is not a law on the amnesty. One of the articles in the law provides for the fact if the criminal proceedings have been instituted, if there is an investigation related to tax crimes, that doesn't review of future responsibility. So I wouldn't call it a law on amnesty. So that law has some positive aspects, and I will try to briefly characterize them. This is a possibility to declare property and thus in 2 or 3 years not to become a criminal. But I haven't heard in your presentation, Andrei Mikhailovich, the questions related to the fact whether that law should be correlated with the law on controlled foreign companies, and to a certain extent, popularization of that law and its liberal nature should promote the inflow of investments from abroad or not. So there was no such person when that law was enacted. Dear colleagues, I'm repeated, let us not invent anything. The president asked a direct question, how much do we want to get from this law? And he said, not a single kopeck. That law has no fiscal purpose. Each purpose will decide for himself whether he leave the funds, shares, property, where he will assign them to the Russian companies or not. That is for the person to decide. There are no fiscal purposes related to the law. That is just a hand given to businesses and citizens to avoid the negative consequences which take into account our law enforcement system will arise if the people in 2 years, if the people do not use that system. Thank you, Andrei.
Thank you, Andrei Mikhailovich. I asked this question within the framework of the trust and confidence. At our roundtable, we're discussing the law on declaring. But in this law, as I see it, we can find a lot of issues that protect citizens and entrepreneurs who otherwise can get prosecuted, because as it has been said, all the information is going to be in the depository of the tax authority, and the law even provides additional protection in case there is a prosecution initiated against the individuals who declare their accounts and property. But I would like to speak about general practice, because I do think that all this is associated with business or with the investments influx. I think this was part of the goal, indeed, because if we take St. Petersburg, the Russian Federation in general, we do understand quite well that at present quite a lot of attention is paid to the development of business environment and conditions that help us attract investments. But not only infrastructure, not only human resource and the credit policy, but the protective measures that can businessmen enjoy are important here as well. So the enforcement practices here should be mentioned. So if we take St. Petersburg again, then in the year 2004 a law was adopted here, 861, on the connection to the electrical grid. And then the amnesty was declared in St. Petersburg, and most of the entrepreneurs, 15,000 altogether, left the shadow sector of economy and began to pay for the energy on the meters readings. And then there appeared another resolution on the use of energy resources without any agreements. And those who voluntarily declared 15,000 immediately began to work in that new framework, and sanctions came inevitably. So they initially they had to pay extra money, and they still suffer because they pay from 2 to 6 times more than those who have the agreement. Well, of course, I can immediately hear a question: why didn't they sign the agreement? Because those who issue the agreements and those who collect money is the same legal entities. So, of course, they're extremely interested in the smaller number of agreements signed. And I would like to cover another issue associated with decriminalization, the respective articles of the criminal code of the Russian Federation. The commissioner, now, when there is investigation and when the case goes to court, then unfortunately the prosecutor's office and the judge begin the hearing on the respective grounds, and these hearings have been going on for 8 years by now in this particular case, and this doesn't boost the respect and the trust and confidence. We discussed this in different entities, including the prosecutor's office, trying to relieve the entrepreneurs somehow, but that's the system. The prosecutors, the investigatory authorities, the courts. Although this article is not present any longer in our law, Article 188 on smuggling is gone. And then another issue, the issue of the prejudicious attitude. So there is one businessman against, there is he's charged with certain things, and the decision now is in the Stockholm chamber. Now the arbitrage courts of the Russian Federation reached a certain verdict, and immediately the enforcement measures were to be taken. Immediately after that, a criminal investigation was started, which stopped all the other proceedings. And in fact, nowadays we are in the process of revising the decisions of the arbitrage and arbitration courts. So, being here today, where there is a large number of lawyers, I would like to ask these questions, and these questions do need legal support, and we have not been able to find any. And the Commission of the State Duma for Law and Order looked into the matter, particularly in relation to Article 188 on smuggling, and we have not been able to find any solution. Well, I give you these examples because beyond each of them, there are real people, there are businessmen, and who can live comfortably if the prosecution continues for 8 years. So practice, to a certain extent, leads to mistrust, although, of course, these notions and the law we discuss are not immediately connected. in this matter. So these are different matters, I think. Trust on the part of entrepreneurs should be promoted through respective work of the law and order enforcement authorities and courts. Thank you very much. Thank you, Alexander Vasilyevich. And now I will give the floor to Mark Raninsky from Egorov, Puginsky, Afanasiev and Partners. The legal regulation, the mechanism of amnesty, disclosure of information, responsibility, liability, and legal guarantees. Mark, you're welcome. Indeed, that is the title of my presentation, but I will probably have to change it because many of the issues have already been discussed. Andrei Mikhailovich spoke about many, but still I would like to go back to some. Unfortunately or fortunately, I do not know what stimulated the adoption of the law, but as a person working with taxes, I can look at the global situation, this sphere of taxes. And I would like to share with you what I can see and what I think should be done, and whether the amnesty is timely and what we can expect after it. We can see that, in principle, Russia is really within the global tax competition. 3, 4, 5 years ago, most tax disputes were associated with the internal market, were associated with the VAT recognition of revenues. Everything was in this field. But over the past 3 years, the focus has shifted. We more often discuss the transfer prices, the fine capitalization rules, the 3-tier shopping, the artificial agreements for tax avoidance, and the exit of profit. Thus, Russia is saying, I do understand where my tax base flows and how to overcome that. The logical step is the development of the rules on the controlled foreign companies, which, contrary to other instruments mentioned, are already legal instruments in order to tax not the corporations, not the foreign corporations, but individuals. A logical continuation of this struggle for taxes is the substrate that is to be introduced next year, that will make it mandatory for the individuals to report on their foreign accounts about the balance on the account. This is all control, and logically from that, amnesty proceeds. We can see that the tax field is more strictly regulated. We can see that we are being supervised, and as Andrei Mikhailovich said, we have just one chance left. So, de facto, we should perceive the amnesty as the last opportunity to disclose the information we keep stored at home. Because otherwise the state is going to be much stricter to us. The legal instruments applied to us, applied for punishment, are going to be quite strict. At least that's what we see. And that's what business is discussing and what our clients are saying. Although, of course, we would like to perceive the law in the most positive way. Now, if we... what was said here, the possession of asset. We do not want it to happen that when the information exchange begins, we all turn into criminals. Just the fact of the ownership of property indicates that we are potential criminals. That's exactly what business is afraid of. 99% of people in business, clients, when we ask them if they want to disclose their assets, just for the sake of security, just for the sake of demonstration that they are willing to cooperate with the state, say no, we would rather not, because they believe this is going to be the violation of rules. So 95% of businessmen who are planning to use this instrument respond like that. As for the law itself, the law suggests disclosure of information about property, real estate, shares, accounts in foreign companies, in Russian companies, in foreign companies where we are beneficiaries, and we don't know if the law is asking us about everything Russian or foreign. Is it possible to disclose? No. What are the limitations here? What if I committed an offense, tax offense, buying an apartment? What if my source is acquired with criminal intent? So is it not there because the state knows about my apartment, or how does it work really? There is no answer in legislation. So it's foreign property as far as I understand from Andrei Mikhailovich, but reading the law I cannot draw this particular conclusion. So that's just for discussion. Can't hear. Now, guarantees. Let's divide them into two sets. The guarantees relieving of liability, criminal and administrative and tax, and even the tax is not going to be collected. The fact that free cheese is offered only in one place frightens off many. No, you can pay to the lawyer, and then the cheese is not going to be completely free. Right, so now that's a way out, if you prefer to feel more comfortable. And the major question with the disclosure and responsibility and liability is the question of the information and what are the sources of the acquisition of property. No matter how negative we are towards this question, but I think that we should pay attention to Mikhail's questions. Is it the first ruble gained or everything else? It's important just from the point of view of understanding what is to be disclosed and what is not to be disclosed, and if it is sufficient or not. Unfortunately, the lack of clarity stops businesses and people. Those who are owners of capital and who have a lot to disclose, this stops them going and declaring their capital. So that capital that I earned 10 years ago selling stock to a foreign company, these stock had been presented to me, but I then invested and had cash and put the money on my foreign deposit and told nobody anything. This happened 10 years ago. Well, let it be within criminal limitation period. And then I used this money for legal business. I received dividends, invested again and again. And so finally, I have a large villa in the States. So if I declare this huge villa in the States, will they relieve me of the liability associated with the non-payment of taxes upon sale? No, I said. And that's exactly what people want to see. No. So the very fact of an ownership of the asset then is a crime, but you can be relieved of that. If we look at life, then the deals with acquisition of securities, houses, transport are all clean and transparent and absolutely clear without any violations. There's nothing there to relieve people of. People want to free their past, their historical risks, but not what they have now. And that's exactly what business requires. And the owners of capital and the guarantees now. Well, it's very good that information is very well protected. The depository in the tax authority. We just hope that we won't see in one of the markets the database of all those who take part in this project. But what is the information that is disclosed in the declaration? It's just the type of property and the owner. And what is in that? How can this be used for criminal prosecuting? It's not clear at all. It's just a vector that the law and order enforcement authorities can make use of in order to claim that property at a later stage. But no matter what we talk about, protection and possibility, there are best practices, there are facts that say no matter how well you try to protect the information, you should not limit the law and order authorities in the country. They are authorized to check if at the time of the acquisition of this property there was committed a crime and whether it is amnestied or not. Well, of course, well, does it comply with the FAT principles? Well, we survive, I hope. No, this law is coordinated with FAT, so there are no problems with FAT. Now, that's important to remember. The only limitation in the law is clearly stated, proceeds from the principles of law, and they concern international agreements and money laundering. And if there is a request associated with a particular name and money laundering, this information is going to be submitted. The law is very specific and clear about that. In the law, everything is absolutely clear. Now, what you are saying proceeds from your first phrase and an absolutely wrong message when you say that the fact of the ownership turns a person into a criminal. No, nothing like that. The fact of ownership doesn't turn a person into a criminal. But even if you have an account and do not inform the tax authorities about them, this is an administrative offense, and you can be fined. But nonetheless, they can come to you and tell you about that. The law does not turn anyone into a criminal, does not presume at all that if you have property abroad, you are a criminal. But the law makes it possible for you to relieve of the threats so that others do not say that to you. And that is for the law and order authorities. So let's not misinterpret what's written there. No, I do not want to contradict your viewpoint. No, it's not my viewpoint, it's the viewpoint of the president. Yes, I understand it. I'm just trying to tell the audience what I hear from the owners from business who are hypothetically looking into the law and looking into the possibility of using it. So this is translation of their viewpoints.
Another question. I have noted it while we were discussing the property that is covered by the declaration problem is restricted by the law, by the declaration, but there is an interesting case. Well, dubious diamonds, works of art. Can we declare them? No. Similar to cash. It is quite obvious. It is in the turnover, and FAT always was against it. When you discuss the property, whether it concerns the property which is in the Russian Federation, you know how there are tax exemptions if you haven't paid the money here. Let us not create the situation when we speak about a transfer from the nominal holder to the real owner, and we don't have the institution of real nominal ownership in Russia. If it were prescribed by the law, that will be a direct road to raiders' attacks, and that would be quite hazardous. For instance, you have property in the Russian Federation, and the holder says that, well, that property doesn't belong to Tutkin, it belongs to me. What shall we do next? Who will win? Andrei Mikhailovich, being a moderator, I would like to give back the floor to the speaker. I can just keep silent. Okay. And the last matter What is the difference between this amnesty and all other similar amnesties in the world? That is a unique instrument, the possibility of transferring property from the nominal owner to the real one. What is the purpose of using that tool? When you have the nominal property, you are sick and tired of it, you don't feel comfortable, and you want to be honest with the state. And, for instance, your house in Cyprus belongs to me, not to Papadionis. I'm the owner, my family lives there, and I spend my vacation there. Globally, that is a very good tool. If let us be outspoken, let us be frank with each other and start our life anew. As to the legal instruments that were proposed to use for that, they are good, but they do not operate properly. To use that option, and the essence of the options is when you receive that property, they shouldn't tell you that this is your taxable revenue, and together with the declaration, you should provide a contract that is subordinate to the foreign law, showing that you have transferred that property to the real owner, to the nominal owner, but you never transfer it because he's buying this himself for the money not received from you. And there is a certain fiction which we come across that should be indicated in the foreign register as the contract under which the title is transferred. It is not possible in practice. The idea is quite valid and sensible. And completing my presentation, if we ask, well, an adequate entrepreneur who has got capital and foreign accounts and companies, who knows what to do with it. If we ask him, are you going to apply amnesty, he will say, I don't know, but my kicks will be destroyed. Probably my foreign account will be declared and I will present the assets known to the state. As to the rest, I'm still afraid and have to think it over. Thank you very much, Mark. I would like to give the floor to Orlov Mikhail Yuryevich, head of the Department of Tax and Legal Consultancy of KPMG Company. He will speak about the correlation between amnesty and the operational taxation rules for controlled foreign companies. Similar to Mark, take into account the discussion. I would like to improvise because I would like to make comments on certain statements that have already been made here. The question of amnesty arose when in the society there were ardent discussions concerning the future law on de-offshorization. So these processes, de-offshorization and amnesty, are correlated in our heads. As to the law that has been currently adopted, it is not amnesty under de-offshorization. This law has a broader theme, a broader object for regulation, and probably that is good. When that state law, draft law was submitted to the State Duma and the government, that law didn't focus on the offshorization operations. And I'd like to remind you that the government submitted the draft law when the working group by 80% has drawn up the text, and the government just signed the draft law that has been prepared by the working group. So we cannot say that the government acted with provided a certain initiative. The government was just a signatory to that law. As to the preamble of the law, there are a lot of beautiful words, but there is no mentioning of the forthcoming or starting company on de-offshorization. So I'm not relating capital amnesty with the de-offshorization package adopted last year. And I'd like to note that amnesty affects a broader range of issues. Yes, among the property to be declared, we indicate shares in foreign capitals. Undoubtedly, that is a certain link to de-offshorization. We indicate controlled foreign companies if that control is not based on participation, on direct participation of the controlling person in the controlled company. If it is direct participation, it is covered by item 1. In addition to de-offshorization instrument, the law comprises other objects not related to de-offshorization, that is, property, transport vehicles, and accounts with the banks. They are not subject to de-offshorization, and it is quite good that the initiators of the law went beyond the scope of the de-offshorization, covering a broader range of matters. I'd like to note that we can formulate a lot of questions to that law, but please note that in addition to the property per se, we can also declare voluntarily. That is not a mandatory attribute of declaration, so you can declare the operations with that property, sources of acquisition of the property, and means of formation of the sources of acquisition. And that is an interesting instrument because it allows, on the one hand, disclosing to the maximum by the declarant and proceeding from his understanding how he describes the sources to present it in the declaration in an arbitrary form. On the other hand, later, proceeding from the disclosure of information on the sources of operations, we can provide the grounds for exemption, relieving of responsibility. If we are speaking about foreign companies, which physical entities in Russia hold. We speak only about the sources of acquiring shares or stock in the company. We're not discussing under the amnesty the assets which these foreign companies acquired. You cannot declare a company in Switzerland and say that everything that I can be later relieved only of the sum spent for acquisition of the shares. As to the origin of the assets of the company, probably I will have to explain that origin. And if I transfer the money to that company from Russia without paying taxes, and if I, accumulate a certain significant amount there, probably the indication of a company in Switzerland in the declaration would not be enough, and that was not the task to be solved. The main sense of that amnesty is a guarantee. I don't want to provide the guarantees related with non-provision of information to all enforcement bodies under the tax secrecy regime under Article 4 to be relieved from tax and criminal responsibility. We have to establish the link between the assets and the property declared and the actions that have been made. This is probably the most complicated thing to be solved by the lawyers later. If criminal proceedings are instituted against the physical entity, and he will have to prove that the declaration relieves him of the responsibility. The link is determined by many criteria. There is a time criteria. If I have purchased property in 20 time, it is not likely that I will be relieved from the actions taken in 2007 because they are not related to acquisition of the property. As to the extent of volume, Mikhail has said that it is not likely that with the help of the property 15,000 euro, I can just say why I have not yet paid the profit tax on 1 billion rubles. It's obvious. In the declaration approved by the law, no cost is given. The declarant doesn't have to give the cost of the property. And to correlate the volume of the property to be declared and the action made, he will have to assess that property and to present it to the investigatory department to determine this correlation. And finally, the question asked by Michael, is it possible just to correlate the ruble earned earlier with the available property? Theoretically, it is possible. Let us not forget about the lawyer's profession, and that will be another job for the lawyers. And I will agree that this is not a tax amnesty. I often hear that that is tax amnesty. That is not tax amnesty or amnesty of capital. That is a unique event or campaign whose uniqueness is based on the fact that no payment should be done to the budget and credit should be given to the draft law without obligation of repayment of the capital, except for several cases concerning some property in FAT countries, without obligation to give the information to the law enforcement authorities, and even the fact that declaration is based on the law and is not submitted for consideration to the Federal Tax Service. No, we know how the Federal Tax Service can interpret the will and draw up the documents, and even in this case, a declaration provides a uniqueness to that company on capital amnesty, and I believe that this amnesty and that declaration is really unique. If we draw a conclusion concerning the specific features of amnesty that I mentioned, I would like to note, can we say that after that amnesty, the transparency of the economy would increase? No one is aware of the property to be submitted under declaration, and no one would learn about it. Can we say that this will result in a return of capital to Russia? I think not, because there is no requirement of returning the capital to Russia stated in the law. Will it increase the revenue items of the budget? Or probably no, because no payment is made. So what does it mean? And I would like to draw an analogy. This is a variety of an insurance policy, an insurance policy that can be acquired by any physical person. That might be an entrepreneur, just a physical person, not engaged in entrepreneurship. He is purchasing a policy. Probably he will never need it. When we receive a policy, we don't think that something will happen. The insured case will come. We just purchase it and put on the shelf. And that is the case when we purchase a policy. What problems can we solve using the policy? If the law enforcement bodies come to us, we can be relieved of responsibility. Probably it will not be easy. That is not a simple operation, but that possibility is available. So we have taken the first step. Does it mean that it increases significantly the favorable entrepreneurial climate in Russia? Of course not. That removes a certain tension, because a policy in any case creates certain comfort, but that doesn't mean that all the risks have been eliminated. So as to the improvement, increasing the favorability of entrepreneurial climate in Russia, we'll have to work on it. That was not a task of the amnesty. Amnesty had to solve the task related to the previous sins and to add confidence and trust to business that it will not be made liable for the sins committed in the past. And I think that that part is solved by the law. Thank you. Thank you, Mikhail. The floor is given to Ladona Ekaterina, partner and head of the legal and practice PricewaterhouseCoopers for CIS. She will speak about the international experience of tax amnesties. Thank you. I would like to say that I have a rather difficult role, because I had a task to generalize the international experience of tax amnesties. That is not as interesting as practical matters and how the tax base now consider the current tax legislation. But preparing for my presentation, I analyzed the experience of amnesties and programs of voluntary declaration of property and assets abroad, and I tried to find some common points or differences related with the implementation of these programs abroad and what is offered for Russia. Undoubtedly, I'd like to say that our program is unique, as has been mentioned today. It is unique along several trends, and the program of voluntary declaration of property really poses a quite different task as compared to the tasks that are traditionally solved abroad. Nevertheless, before passing on to the brief characteristic of differences and common points, I'd like to say that if we analyze the international practice, the experience of voluntary declaration of property operates successfully when, as we have already said, there is trust and confidence to the state among the taxpayers. There are clear rules of actions based on administrative practice of applying tax law and the rules established for the declaration. On the other hand, it is quite important to use the instruments that the tax bodies can use to control the payment of taxes by the taxpayers. And taxpayers, in my view, always choose proceeding from the balance of risks and opportunities. And as for the international practice, probably you will see that in the international practice, such programs have existed for a long time, and they are applied on an annual basis. But in principle, the main issue related to implementation of these programs is based on the fact that foreign tax authorities have a very rich instruments to control the taxpayers. These are the questions related with stringent legislation concerning the restrictions of using offshore elements for optimizing the tax basis, transfer pricing, questions related with information exchange, and probably the most interesting incentive for expanding the programs of voluntary declaration abroad was given by the practice associated with exchange of information and financial institutions, for instance, on demand of the tax authorities. And today we have already mentioned that the international law will introduce in near future new instruments related to the information exchange, not only under international agreements on dual taxation, but also related to the new instruments, particularly the instruments of automated information exchange, which Russia will also join from 2017, and with the new rules that have currently been proposed for disclosing of beneficiary owners and other similar measures. As to the practice of OECD countries, the most significant reforms that also affect the Russian environment are the initiatives or reforms formed and developed in OECD countries, taking into account BEPS plan. As to the present-day situation, we'll probably see that I agree with Mikhail that the law on voluntary declaration per se is not directly related.
It is not directly related to the de-offshorization and respective legislation, but nonetheless we are at present at the very beginning of the acquisition of the practical experience in the associated with the reform of taxation, because this reform made it possible for us to analyze all the information in much more detail, so that the kick rules and the rules of the tax residency and other rules. And I think that with this type of instruments, we get an absolutely new environment for the potential control over the taxpayers, over their activities. And this is a risk factor for those taxpayers who do not want to disclose their property or their revenues or their profits abroad. And in this sense, the law on voluntary declaration of property provides a unique opportunity to overcome the tax and legal risks associated with the obtaining of the property, and makes it possible to turn the page and allow the businesses and the taxpayers to start their life anew. In parallel to this, we have also interesting amendments to the tax authority. Dmitry, who speaks after me, will tell us about them. Amendments to Article 217, which make it possible to return the property back to Russia without paying taxes. And we can see that many of the taxpayers are really interested in the simplification of their structures. And they want to make use of the legislation advantages and do return some of their property to Russia. The new legislation on controlled foreign companies creates very rigid conditions for the taxpayers, because if you try to understand what the taxation base is for different types of businesses, we will see that tax burden goes beyond the one that you will have following the American rules. I looked at both of these laws because both of them create very new opportunities that did not exist in the past. And thus I wanted to mention that if we compare the current law on voluntary declaration of property, it does differ from the international practice. First of all, because it allows to start new life without any additional taxes paid. Tax guarantees are provided. And if you look at a similar program abroad, I do know that we are not discussing these today, but usually abroad, the benefits provided in connection to fines and to penalties or taxes are not applied to the if there is an inspection of the activity of a certain taxpayer. But with us, this norm sounds in a much more mitigated form, because we're talking about the application of the law only if that there is an administrative or criminal investigation initiated against the taxpayer. So this really expands the range of taxpayers who can enjoy this particular benefit. But that's Dmitry's story of the taxes and Russian legislation. So that's all I plan to say, Dmitry. Thank you, Ekaterina. Ekaterina has already announced Dmitry Mikhailov, who is partner of Ivanian and Partners Bureau, and he will talk about the tax aspects of the capital repatriation within the framework of de-offshorization. You're welcome, Dmitry. Thank you. I would like to speak about the tax aspects of repatriation of assets in the context of de-offshorization. First of all, what do we understand by the process? First of all, it's the return of the shares of the movable property of the chattel that belongs to foreign companies. The return of these types of assets under the control of the Russian tax residents within the framework of the voluntary declaration of property in compliance with the respective law adopted by the Duma after 3 readings, and also within the framework of the law on controlled foreign companies. And there are 2 things to be mentioned. The stimulated repatriation of assets to the Russian Federation is carried out by the legislators who introduced the mechanism of the taxation of foreign companies. So it makes it quite burdensome to own assets through a foreign company. And then it also envisages certain benefits if the assets go back under the auspices of Russian taxpayers. And the Russian taxpayers could be also interested in the return of these assets under their control. For such reasons as the risks and claims of the foreign jurisdictions, the economic sanctions, as we know, a preferable tax regime, and reduction of the cost associated with the administration of foreign companies. Now, and what do the legislators do for the repatriation of assets? There are certain norms associated with the controlled foreign companies and benefits if these structures are being liquidated. Then there is a law on the voluntary declaration of assets. So a few aspects that are of importance. First of all, the mandatory character of repatriation within the framework of the voluntary declaration of assets. Article 6 of the law on voluntary declaration of assets, repatriation of property is not mandatory, except for those cases when the respective chattel is in the states or in the territories of the countries which are within the lists of FATF, or in the states which do not provide exchange of information, tax information, with the Russian Federation. And, well, these conditions might evoke certain practical problems. If we take a declaration without documents for securities associated with the Rostov company. Many of the tax residents in Russia own companies in BVI, for example, which is in the blacklist, and respectively. If the rights for this company exists only in the form of non-documented securities, then of course it is very going to enjoy the provisions of this law. This question has already been asked. Moreover, there can be a practical problem with the declaration of the vehicles in these jurisdictions, because their repatriation to the territory of the Russian Federation might be accompanied with rather heavy customs and tax payments. Now, a few words about the procedure of the transfer of property from the nominal owner to the actual owner. What is the problem here? The State Duma adopted the amendments for the Article 39 of the tax code, where the transfer from the nominal owner to the actual owner is not recognized, and other amendments which do not recognize the economic benefits if the transfer is carried out. But the legislator does not settle the matter of the tax value of this property. There is nothing in this law about the costs that the taxpayer might take out of the tax amount, and this definitely makes it possible makes it difficult to calculate the tax base during the resale. Now, repatriation of property within the framework of legislation on controlled foreign companies. Here, the amendment of Article 217 of the tax code is very important. During the liquidation of these companies, the property, except for cash, is relieved of taxation. Now, I think this norm can be quite popular and can be applied by the individuals. But in the past, similar relief was provided for legal entities who also were not taxed for property obtained during the liquidation of the controlled foreign company that belonged to them. Now, there is a certain difference to taxation of legal entities and individuals. It is not clear why the cash is excluded from non-taxable assets. This limitation can be easily overcome through the acquisition of some other property before the procedure of liquidation. And then there is a difference in the approach to the definition of the tax value of the property obtained by the controlling individuals during the liquidation. For the individuals, it's quite easy. It's the value on the basis of all the accounting documents, but for the legal entity, it's also limited because the investments in the controlled foreign company are also considered. I would like to draw your attention to another problem that we believe is quite significant, namely, the legislator envisages the terms of liquidation. The liquidation must be completed by January 2017. We believe that this might be difficult to carry out if the factual owner wants to repatriate through several companies. And we know that it's quite common when the Russian asset is controlled by a Cyprus organization that enjoys the respective benefits on the basis of the dual taxation. Then above the Cyprus company, there is an offshore company that is managed either belonging to a nominal shareholder or maybe to some trust that pays royalty to the beneficiaries. So liquidation of the structures that is something quite complex by January 2017. Moreover, we believe that there might be certain limitations associated with the fact that controlled foreign company does not belong to the Russian resident to 100%, and in this case, a foreign participant might find the whole situation difficult. So we can draw the following conclusion. Since we see that the legislator makes attempts to relieve the repatriated assets, the state is interested in the repatriation of the property of its citizens. And if we assume correctly, then the list of grounds should be extended at which the repatriated assets are relieved of taxation, so that there is no need of liquidation of the whole chain of companies, and so that be a free transfer, the transfer and the payment of the well, in kind and in cash. And so these could be ways out for the Russian taxpayers who want to carry out repatriation. Dmitry, thank you. And now time has come to ask questions. And if there are questions, good afternoon, ladies and gentlemen. Dmitry Klonov. I have a general question. But with a specific example. I heard from Andrei Mikhailovich that this is not so much amnesty as an act of the declaration of property. And you gave the example of an apartment and with teaching. And I do not quite understand what is the problem of the ownership. Most probably during the acquisition of this property, everything was all right. So what is the problem with that? And if that teacher is visited by a police officer for non-payment of taxes, then Amnesty might help with that. But of course, there will be some other student who will say that the teacher, the instructor, has not helped with admission to the university, so this could lead to a criminal charge. So what we come across quite often is an offshore company with a nominal shareholder, with the owner who actually receives the profits, and it's managed from Russia. With Amnesty, we can declare, we can distribute these resources, recognize the company a nominal holder, and distribute the assets among the individuals. But if the company is managed from Russia, then there is a long-term violation, and there is a risk of the company to be recognized as a Russian tax resident. If I understand it correctly, so I'm addressing the best legal minds. This is not covered by the amnesty, is it? The answer was not given through the microphone. Interpreters cannot hear. Well, I did not understand your question, frankly speaking. So the best legal minds did not understand it. Accept interpreter's apology. We cannot hear if the microphone is used. So if you continue with what you had been doing, the illegal optimization, then there's no point to declare assets. So either you liquidate that particular scheme, beginning with January 2015, or and then you declare. So no, the date is the 1st of January 2014, because that was associated with the declaration campaign on the declarations that we have for individuals. We were afraid that otherwise we would get problems with the payment of regular taxes. But if the violations still occur after that period of time, that is simply an improper type of behavior. Moreover, there is a rather simple technical answer to your question about this. It's difficult to speak about this lengthy violation. There is the object of taxation, and there is the time when it exists, and there is always a certain tax period, and you can see whether it is covered by the amnesty or not quite easily. Any other questions? All right. It's either everything is so easy and simple that you do not have questions, because I have many more questions than answers. Then some conclusions for today. It seems to me that Andrei Makarov gave us a wonderful pre-story of that legislation, and I agree with him to 95%. The law is much better and it works. But 5% I can say it doesn't work for everyone and does not work fully. Well, as Makarov says, it was not planned for everyone. So drawing conclusions...
So there are two trends for which it should work and probably would work. First, potential cessation or termination of historical risks related to tax and currency violations, related to declaration of property. And the second possibility, non-related to violation, possibility of transferring from the nominal to the actual owner without paying taxes. Two different conceptual approaches that were covered by one law, and we debated it with Andrei Mikhailovich, who stated that these should be regulated by different laws. And summing up the results of our session, I would like to formulate my personal opinion by a well-known saying: he should be assassinated and not pardoned. I don't know where I should put the comma. I hope that before the end of amnesty and the doors of the tax inspectorate close, there will be some additional explanations, and probably there will be some minds who will clarify to the entrepreneurs everything, because eventually that is intended for business, that is meant for business. Common citizens do not use the notions of offshore companies, composite corporate structures, and the law is targeted at foreign companies and foreign accounts and foreign property. So for the business to take decision whether to implement it or not. We need serious advertising that has already been started and it is successful, which is quite often the fact here. And if there are some additional clarifications or explanation till the end of the declaration company, and it ends on the 31st of December 2015, afterwards it will be late. That is your last chance to submit the declaration. So, no microphone is used. In 4 days, on the 2nd of June, we're going to have parliamentary hearings at the State Duma on the main trends of tax policy. It has become a very important event at the site of a conference of the plenary conference hall. There will be Silianov, Nareshkin will be convener, and the governors will also participate in it. We're going to discuss the main trends. From my viewpoint, we discuss whether business will just take it into account. Citizens, that will be important for citizens. I don't know whether it will be needed for businessmen. Everything that is done by the Minister of Finance for our tax policy that undermines the previously competitive tax system. When we wrote the general part of the tax code in '98, when we added the presumption of innocence of the taxpayer, that was the first time when it was in the tax document, and the burden of proof was assigned to the tax authority, because we knew that there was a bias towards the state, and it will continue for many years to come. But we were writing it for the future. When at the beginning of the 2000s we get a competitive tax system, not only for the general part, but also for the tax load. And now, if you have seen the basic trends of the tax policy for the first time in these years, and I have tried to prove to Minfin that we have to compare our tax system not with Germany or the USA. We have to compare it with developing countries, with our neighbors. Well, they said that we had a wonderful load, and two arguments were found by the Minister of Finance. Our tax load is less than the average tax load of the OECD, and then we have to consider our tax load without oil and gas revenues, and you have to distract it from the GDP. When this work was done for the first time this year, we can see that we have a tax system that is not competitive in respect of the tax load. When business decides whether to come back here or not, they can declare just to be on the safe side. It is senseless to speak about returning business here. Business will not operate in a non-profitable tax system. When we consider the main trends of the tax policy on the 2nd of June, we have to realize what should be the tax policy of the state. The most important component, we speak about trust, confidence, and investment climate, but we managed within that time period, the Minister of Finance managed to kill the tax system of the country. A very important step was made by the president. He said for 3 years we shouldn't increase the tax load. That doesn't mean that we shouldn't amend the tax code and improve tax law. And even now we have to prepare the proposals and to how we're going to decrease the tax load in what spheres. And finally we have to recall that the entire tax load is without non-tax payments that have to be taken into account. The Minister of Finance doesn't take them into account. We have to create a competitive system, but unfortunately, so far, the Minister of Finance sees only one threat, the aim of the taxpayer to evade paying taxes. As to the challenges that emerge related to competitiveness, and the trend of the tax system that should be based on providing the incentives for the economy so that it be possible to attract capital and workforce to compete at the markets. We don't have anything of the kind. If the question that was raised here would come to business, that depends not on the law to be adopted now, but on the system, tax system. It was mentioned that there are some problems related to business. These are not tax problems, and then we have a whole set of problems. On the one hand, there are problems not related with taxes. Sometimes we try to find them using tax laws or means. And the second, we have to recognize that tax system is not competitive, and we have to amend it. If we solve these problems, then what was mentioned by Mikhail can be realized, but it's not related to the law. Thank you very much, Andrei Mikhailovich. Oleg, I would like to conclude this session. I hope that this roundtable today was interesting and useful to the participants of the roundtable. I would like to thank Andrei Mikhailovich for participation in that discussion, and all the colleagues and all the speakers who participated in that discussion. I would like to thank you for having attended our roundtable. All the best to you. Goodbye.
Очень интересная дискуссия, очень интересный круглый стол. И просто я хотела в качестве информации сказать, что вот у нас в настоящее время в Казахстане сейчас как раз-таки с 1
In Kazakhstan, from the 1st of September 2014, in last June, we adopted the law on capital amnesty, and now we are starting to legalize the capital that will last till the end of December 2015. We analyzed it attentively while preparing. There were a lot of hazards, but the people are coming, business are coming. And we're discussing it quite in great detail. I think that these hazards, which many people have now, are not justified. Thank you very much once again on behalf of Financial Group of BKS. Thank you for participation in our round table.